legislative measures, as I said, to give us that multiplier effect. Because we don't have the numbers, we don't have all the skills, etc., etc. We presented our case. There is a response from the government with some proposed legislation. All we're asking is for those charged with making legislation and those with the inputs is to understand some of the difficulties that we're having. And if they understand and accept it, some may not accept, because some, as the Tavares Vincent just did, is throwing it right back at us, and we accept that. As I stated, understand the issues we have, understand what is happening out there. That is your duty. To craft the kind of arrangements, if you deem it that we really have a problem, we have a crisis, and we do. And you craft the kind of arrangements that's going to keep us accountable, give us some help as we improve the quality of policing, which we know is bad. Now, if we believe that there is a crisis necessitated,
does the data exist as to what types of offences, what are the percentage where they're granted, what are the percentages where that has led to?
And as I said in my brief presentation, we acknowledge that there are shortcomings on our part at times. We have gone through to look at where second offences have been committed for offences of murder. So people have gone on to die because people have been given bail in the first place. What I'm unable to do, but I would think that it's a job perhaps greater than that of the police, is to analyse each of those 70 or 80 cases to find out why was the person granted bail. Is it, as the Senator said, on each occasion because of the inefficiency of the police, or are there other reasons as to why bail was granted? Now, I'm aware of cases, but again, I'll go back to Senator Golding's point of anecdotal, because I don't have the detail, but I could give you cases where we have been shocked that bail has been granted when all the work has been done. And there are many of those cases as well that for some reason a judge or a magistrate has decided to grant bail. So there are, on both sides, we accept there are deficiencies on the police, but I think we can refuse to take all of the blame. And again, we have moved a long way in the last few years in terms of how we're managing our cases and investigating them, but we still have...
Is it that under the given circumstance, you need this additional time to ensure that you can deal with the workload?
What we asked for was speedy trials for certain offences, gun offences, because we have a situation where there are over 23,000 gun attacks on our citizens in the last 10 years. Over 4 murders per day, 4 shootings per day. The persons held with guns are the murderers, the contract killers, the extortionists. Our concern is that these people, their trials take too long. And when they are on bail, they are re-offending. And what we have produced here today is a list of 74 such individuals who were charged for murders, shootings, serious crimes, and granted bail, re-offended, committing more murders, more shootings, and are still on bail. So our concern is about the persons who are not going to abide by the law whilst they're on bail, and we wish if those individuals will be given speedy trial. We never ask for 60 days detention before bail is to be granted. And what we're asking for is speedy trial, and if it is the view of the court, those persons need to be remanded for a week, 2 weeks, a month, whatever it takes to try them on these offences. That is what we support.
The basic facts that at Bay Royal we discussed this matter, and the police who were present said they wanted more time. We had a subcommittee meeting where we went back to Bay Royal. A member of the group at Bay Royal suggested 90 days. 90. And in discussions, we felt that 60 was more appropriate. And that included the discussions that we had with the police. So it was 90 days suggested by someone, it came down to 60.
And I think you should add that the 90 days did not come from the government, it came from the opposition.
we in the prosecution are seeing is that we now have a situation where the thrust of coming to court after somebody is arrested and charged is not necessarily for a speedy trial, which is what the gun court was originally set up for. What we are having is a situation where the thrust is, okay, you apply for bail, you get bail, but for ourselves, we are having a great problem in encouraging witnesses or getting witnesses, and the police are having it, to come to court, because the time-honored complaint of witnesses is that, but miss see the man back out in the community and he's walking up and down with his friends and his gang. How can I come out, have to leave the area? So what you have is the accused getting bail, and then 2-3 years down the road, we cannot try the case enough to offer no evidence. So the pendulum of justice must swing both ways, and I continue to cry that it is not only the rights of the accused persons that must be considered, but the rights of the general society, where people have a right to go about their business unmolested, and if they have a complaint, they must be assured that we are all united to make sure that there is a speedy trial. So the quibbling about 60 days or whatever, I regard that, speaking as a prosecutor, as a matter of policy. It is for the parliament, who are here as elected representatives of the people, to assess the situation in the country and to decide what is the policy. Once the policy has been decided, then we have to obey and implement. But what we would like to bear in mind, that you have the rights of the accused, but you have the rights of victims and witnesses to be able to come to court unmolested and to know that there are certain things that are put in place that will allow them to come to court. Not a situation where they go on the cover of night, give some oral statement to the police, and within 1 week of the accused being arrested, clear eyewitness evidence, he's seen back out in the community, walking up and down with a gang. And it has happened, I have had the experience, where a witness has come to court time and time again, a witness in the gun court who actually knew the accused, and comes for the defense, came and made a great plea about a medical. The accused was not there. And once the witness came to court, so he could be bound over, and within 2 days I was made to understand that after leaving court, he was shot and killed. And thereafter, the following week or two, the accused appears in court. And the defense had a great explanation as to why it was that he was not present. So
Section 50, Section 3 goes on to say, any person is arrested or detained for the purpose of bringing him before a court in execution of an order of the court, or B, upon reasonable suspicion of his having committed or being about to commit a criminal offense, and who is not released, shall be brought without delay before a court. And if any person arrested or detained upon reasonable suspicion of his having committed or being about to commit a criminal offense is not tried within a reasonable time, then without prejudice to any further proceedings which may be brought against him, he shall be released either unconditionally or upon reasonable conditions, including in particular such conditions as are reasonably necessary to ensure that he appears at a later date for trial or for proceedings to a preliminary to trial. Now, just to deduce from the constitutional provisions, in effect, what it is saying in simple lay terms is that once you're arrested, then the Constitution prescribes you shall be brought without delay before a court. And once you're brought before that court, a trial should be proceeded with within a reasonable time. If there's no trial within a reasonable time, then that is where the constitutional right to bail is triggered. And the judge now will have to prescribe the conditions upon which you should be